Hey folks, welcome back to the Wikipedia world, and I am Abhinay Gupta. And today again we'll continue with the appointment and remuneration of the managerial personnel. Right, so how many of you actually liked the previous lecture? A little different, right? So basically the entire purpose of the previous lecture was to give you an insight and the base of the entire chapter, right? Because once you know who the managerial personas are, and you know the exact essence of their position, right? Then relating to their appointment and remuneration will make a lot of sense. Agreed to that, right? So today we move ahead. We are done with the basics. We have done with the understanding of the three positions, right? Now today we'll understand the appointment of MD, WTD and manager. That means today we'll understand their appointment of all the three, right? There are certain disqualifications too that we'll be discussing. So let us see how they are appointed. So first thing to be kept in mind is that a managing director and a manager both cannot prevail in the same company at the same time. I told you in the previous lecture as well, right? A whole-time director has to be there, right? So the company has one or more than one whole-time director, but along with the whole-time director, the company can either have a managing director or a manager. In the case of a manager, it's only one manager, and in the case of a managing director, it can be one or more managing directors. Okay, so that is the first clause in their appointment. The check. Do you have a manager? Then don't appoint an MD. Do you have an MD? Don't appoint a manager. Do you have a manager? Don't appoint even another manager. Right? That is the first thing that we need to check in the case of an appointment of these three. Right? Second, tenure maximum 5 years. So may it be a manager, may it be a whole-time director, may it be a managing director. The tenure for which they hold that particular office would go maximum to the period of 5 years. Right? That means you cannot, by any agreement, by your article, by your board of director resolution, by your members resolution, anything, right? You remember all these four clauses? An agreement, article, agreement of, the meeting of the board, meeting of the general meeting, right? The meeting of the members. These are the four platforms from which a managing director is appointed, right? So any of these platforms, they can only appoint a managing director, but cannot extend its tenure to more than 5 years, right? But again, this clause for a tenure of maximum 5 years will not be applicable on the government companies, right? And that has been laid down via a notification. So there's nothing as such written in the law, right? But if you refer to the notifications, yes. If you want me to read out the notification or give out the notification number, so it is notification number GSR 463E, which was dated 5th June 2015. So as per that notification, right, this provision shall not apply on a government company. Okay, it will apply on all other company in the same front, public company, private company, or any other kind of company. Only on government company this exemption has been granted, right? Now disqualification. Now there are certain disqualification which if attracted you cannot appoint that person, and after appointment if it is attracted that person is disqualified, right? He has to vacate the office. So a company shall appoint or continue the employment of any person unless and until these disqualifications have been attracted to that person. So the first, 21 to 17 years age, which means a person who is below the age of 21 years, right, shall not be appointed as a director, shall never be appointed as a managing director, whole-time director or a manager, shall never. And the maximum age limit has also been capped to 70 years, right? But this is not a never case. This is an occasional case. That means, okay, at some point of time, if there is a person who has crossed the age of 70 and still either wants to continue in the position of director or you want to appoint somebody who is beyond the age of 70, then you can do that subject to certain requirements. Right? Now, what are those requirements? That appointment is to be made by passing a special resolution in the general meeting. First thing. Because it's a special case, it's not a general phenomena that you appoint anybody over the 70 years of age to be the director of the company. I mean to be the manager, managing director, or the whole-time director of the company. Now, here forward in the chapter, I'll not be repeating these three names over and over. What will I say is the managerial personnel, right? As the chapter also says. So, appointing any managerial personnel in the office beyond the age of 75 is a very rare phenomena, right? And for that, you need to pass a special resolution. Plus, that special resolution will be accompanied by an explanatory statement, which will indicate and which will give the justification of why did you go ahead to appoint someone beyond the age of 70 as a managerial personnel. Didn't you get anybody below that age? Right? Or is there something special about this person whom we are appointing? Or whatever be the case. Right? You will have to justify it with an explanatory statement that will be annexed to that special resolution passed by the members in the general meeting. Right? Now beyond that, that was the first point. Second is undischarged or anytime insolvent. So this is a conflicting statement, I would say. First of all, the statement says that a person who is an undischarged insolvent is disqualified. Now, who is an undischarged insolvent is one thing you need to understand. So I guess being law students, all of you know what insolvency means, right? Bankruptcy. That the person does not have any money. Now, if somebody is bankrupt or if somebody is insolvent, do you think they just go ahead and say, look, I don't have money? No. The court has to declare them insolvent, right? So the court has charged them with insolvency. When we talk about undischarged insolvent means somebody whose insolvency has not been discharged by the court, means who continue to be insolvent. Who continues to be insolvent. Because once the person gets out of his insolvency, he again goes back to the court and says, listen, I'm no more insolvent, please discharge my insolvency. And the court does that with a certificate. Right? So if there is any person whose insolvency is not discharged, that means with an undischarged insolvency, that person shall not be appointed on the board. Right? First. Then the second continuing statement says, or has any time been adjudged as an insolvent. Obviously, if somebody has been adjudged as an insolvent, only then the discharge takes place. Right? So in the first part of the statement, they say if the person is undischarged insolvent, disqualified. They mean to say that if he is discharged, he is qualified, right? But the answer is no. Because the continuation statement says, or has any time been adjudged as insolvent. So even if he is discharged, even if he is not discharged, he has been declared insolvent once. So if you have ever been charged with insolvency on you, you cannot be appointed as a managerial personnel in any of these companies. Right? Next, a person who has at any time suspended payment to his creditors. Now, what do you mean by suspended payments? Two things. It's not only about suspension of payment, it's also about composition with them. Right? That means you had a lot to pay to the creditors, but you suspended the payment. You said, I'll not. Right? Or you went into a settlement with them. See, I'm not in a position to pay 2 CR. So could you manage somewhere in 1 CR? Or would you go ahead and file a case and everything and manage it at 0? Either take 1 CR or let's fight a case. So creditor says, okay, let's take 1 CR. Right? So if you have ever suspended the payment, right, or you have gone into a composition with them, in both cases, you'll be disqualified because you're not supposed to do that, right? Second, last one, a person who has at any time been convicted by the court. As we say, convicted by the court for more than 6 months. It says a person who has at any time been convicted by a court of any offense. Remember, earlier we used to go through when we go to the directors, it's an offense of moral turpitude and those kind of statements you find over there. Over here, it's not about moral turpitude, it's not about anything. They say, in general, if you have been convicted for any offense, I don't care what it is, and you have been sentenced for an imprisonment of a period for more than 6 months, not up to 6 months, more than, right? So if your imprisonment is not 6 months, qualified, more than 6 months, disqualified. And that conviction can when you're convicted, that can be for any damn thing, but it has to be an offense, right? Not any damn thing, it has to be an offense. So we have seen all the disqualifications that can be attracted, right, to the managerial personnel. Okay, now we move on to the next clause, that is 196 Clause 4. So what does this has to say? It deals with the approvals that are required for any managerial person to be appointed. The first approval comes from the board, right? So they see, if you actually go into the detail in the chapter, that the text that is upcoming, so you will read a lot about section 197 and the schedule 5, right? That is regarding the remuneration and everything. So those things are all already there, but subject to those provisions, right? The terms and conditions of appointment of these managerial personnel will also be decided by the board first, right? Whatever the remuneration is payable by him shall be decided by the board. So the board of directors, they'll hold a board meeting, and in the board meeting they will decide as to which managerial personnel should be given what remuneration, right? Then they'll project it forward. Then the board will get into the meeting, the board will decide, and with the majority vote, the board will decide what remuneration is to be given. The board will approve the remuneration, right? And then once the board approves the remuneration, it has to be again approved by the members in the general meeting, and that will be taken for approval in immediately next general meeting that is held after that board meeting. So once in the board meeting you have fixed the remuneration, into the next general meeting, whenever it happens in that particular general meeting, you will go ahead and get the approval for the same from the members, right? And if there is any deviation, if there is any variance to the conditions which is specified in schedule 5, then even the central government's approval is required. So either you follow schedule 5, if there is a deviation in the schedule 5, you please contact the central government, right, and get the approval from the central government, right? And the approval from the central government will have to be received, like you'll have to file an application, right, for approval from the central government within 90 days of such appointment, and that will be done in form MR2, right? So within 90 days of your appointment, please inform the central government or take approval from the central government. So these are the three steps: first the board, then the member, and then the central government if needed, right? So the central government will not be sought out for any approval unless and until there is a deviation from schedule 5. If you are going ahead and giving the remuneration and everything as per schedule 5, it's perfectly fine. But if there's a deviation, then that deviation will not be entertained without the approval of the central government. It's as simple as that. Okay? And this provision is not applicable on the government company. Right? As far as this is concerned, what you need to understand is that this is not applicable on government company as per the notification. This is also not applicable on the private companies, right? So this clause is not applicable on them, any of them. Okay. Now what is applicable, that we'll see later when we are discussing or dealing with the government companies individually. As of now, what you need to understand in section 196 is that clause 4 of section 196 will not be applicable on government as well as private company as per the notification 463E dated 5th June 2015. Right? Next we talk about the notice. So whenever you are appointing somebody or whenever you are paying the remuneration, you have to discuss those things. So there has to be a meeting, right? Even if it's a board meeting or it's a general meeting, it has to be a meeting. And for every meeting you rotate or you float a notice. So the notice of either the board meeting, right, and another general meeting, both, which is called for the purpose of approving the appointment of these managerial person. That notice shall always include the terms and conditions based on which these appointments are being made. So if I'm appointing a manager, if I'm appointing a managerial person, any managerial personnel, right, there are certain terms and conditions that I'll agree upon with respect to the powers given, with respect to everything, right? So the terms and conditions has to accompany the notice which has been sent to the directors for the board meetings and to the members for the general meeting, right? And in the notice you will also demonstrate and you will also like point out that okay, this is the remuneration also that we are planning to give to this managerial person, because again when the board meeting is conducted it has to be decided. So the directors need to be prepared that okay, these are the topics and this is the amount and this is the person. So they'll make up their mind and then come for the board meeting and conclude. Similar things happens with the members. They'll do their part of study and then they'll come and then they will approve it. Right? And if there is any other matter that you think you should be including it, right? Like if the director has any interest in that appointment, okay, then even that you'll have to mention in the same notice that you roll forward for the meeting that is to be conducted, either the board meeting or the general meeting of the members. Got the point? And even this provision will not be applicable on the government company as well as the private limited company. Right? These procedures are not required because it cannot be applicable on a private limited company anyways. So let's not talk about it. Right? Because whom do you see in a private limited company? Minimum number of members and directors, right? You cannot have more than 50 anyways. So to those people, they already know whom they are appointing, what they are doing, not doing. So it's just a formality if you send them to send a notice for these things. It's not required, right? But in a public limited company and stuff, it indeed is required, and so they specify that okay, for government company and private limited company, don't get into unnecessary hectic task to perform. Just go on with operating your company instead of complying with the provisions. Then you also need to file the return with the registrar, and this procedure has to be done within 60 days of the appointment of the managerial personnel, whosoever it is. Right? What return do you need to file? Obviously, you'll need to file the return of appointment, and that is also to be done in the prescribed form. And Rule 3 prescribes that form, which says the form would be Form MR1. And if you know, then the same form is also required to be filed in case of an appointment of a CEO or a CFO. Right? So apart from these three managerial person, Form MR1 is to be filed. It's a return that is to be filed for appointment to the registrar for these three managerial personnel as well as for the CEOs and CFOs of the company. Right? And it has to be done within 60 days of appointment. Got the point? Last thing that we need to see in this section is the validity of the act if appointment not approved in general meeting. So now what happened, if you see, first of all, if you see the entire scenario, you decide, you think that okay, this person should be taken up as a managerial personnel. So what do? Is you propose the appointment of that person, you decide the remuneration, and you attach those documents along with the notice that you are sending for your board's meeting. Right? The board of directors, they sit for the meeting, they undergo this discussion, and then they approve that okay, this person is eligible. So let's do one thing, let's appoint this person as a managerial person in our company with so and so remuneration. Right? No disqualification attracted, all the work is done, a fit person, a sound person from mind and everything. Now what happened? The board of directors appointed them, and now when will they be ratified? I would say by the members in the general meeting. You will not call an extraordinary general meeting. Whichever is your next general meeting, right? In that general meeting, you put up the topic, and then you file a return for. You put up the topic, and then you decide whether or not the members also agree with such an appointment. If the members agree, right, then you move ahead and check whether Schedule 5 has been followed. If not, then take an approval from CG. But now in this section, what it says that there's a break. Break where directors agreed, but the members did not. But when did the members deny? Members denied it in the general meeting, which was held after the appointment of director in the board meeting. Right? So this procedure is not so lengthy that once the board appoints and then you will wait for the general meeting, then you will wait for the central government approval and then you will get that person to be on the board. No, it's not done that way. When the board authorizes the appointment, or when the board approves that okay, let's appoint this person at so and such remuneration, then the person takes charge of the office. Right? And then if there is any deviation in the general meeting, then it is taken care of. Otherwise, the person continues. Right? Because if the board is appointing, right, the members are also, there's a 90% probability that they'll also appoint the same person. Unless and until there's a conflict. Right? So the operation is not stopped. That person takes charge of the office and starts his work. But now if the members of the company, they deny the appointment in the general meeting, that person ceases to hold office anymore. But whatever that person has done from the date of his appointment as per the board till the general meeting where he is not appointed, where the appointment is not approved, all those acts done in between will remain valid. Right? So that was the basic understanding of this section, that if there is something that is done after his appointment till his appointment is either disapproved or he's disqualified or something, all those acts will remain valid. Right? That is all about this section 196. We are done with the entire section, and just remember all those things that we have discussed: file and return with registrar, disclosure in the notice, validity of the act of appointment. All these things, they do not apply on the government company or the private company. Just keep that in mind, because if you see the appointment list that we had discussed, that is not applicable on the government company or the private company, is also continuing in these clauses about the validity and about a lot of things, right? So that is very much sure that this will not be applicable on the government or the private company. Otherwise, things remain same, right? And that's all about section 196. I'll see you guys back in the next lecture with the discussion of schedule 5, right? So we'll take that up in the next class. Until then, this is Abhinay Gupta signing off. Thank you and bye-bye.